Today on this lecture video, we shall be talking about in extenso section 24 of the Criminal Code, which is the chief host that governs offense as far as our criminal law is concerned. In case you are watching this video from Nigeria, in case you are from the northern part of the country, in case you are in Kenya, in case you are in Uganda, in case you are in Cameroon, in case you are in Ghana, basically any country that deals on what common law, I encourage you to watch this video to the end, because in as much as the section may be different, but just know that once you can identify that very section that talks about element of crime in your own country, whatever I'm going to say applies. So I'm not ignorant of the fact that most of you are not from Nigeria, but I always use Nigeria as a perspective to your own law. Remember, I cannot be everywhere, but whatever I'm saying is common law based, and it will be of great help to you. By the way, my name is Kingsley Ifeanyichukwu. As at the time I'm making this video, I'm currently in my 400 level, and what I do on this channel is to help all law students, especially those who are intentional about their sources, those who knows that there is more to law than what the lecturer gave in the classroom. I encourage you, if what we do, if you're interested in receiving updates, just updates about legal topics, subscribe and turn the notification to all. Just press the notification and it will show you the option of all notification. If you turn it to all, the import is that whenever we post a video, you are going to receive it as a notification. If it's something that resonates with your level, you can watch it and see how it helps you. Now, without further ado, I don't have much time because I want to make sure that I touch every single thing under section 24. So we won't waste much time, and I believe God will help us to save and utilize time so that this video will not be long as I'm hoping for. Now, let's move immediately to section 24 of the Criminal Code. I will start by quoting it verbatim so that you will understand what section 24 is all about. So section 24 of the Criminal Code is the heartbeat of criminal law, and he's talking about what? Mens rea. That is the mental element of crime. It basically governs when a person is criminally responsible for an act or omission, and when they are what? Not responsible. Read section 24 together so that we'll use it as a point of contact and analysis as per everything common law has to say about intention and element of a crime. So, subject to the express provisions of this code, relating to negligent acts and omission, mark that thing, subject to the express provisions of this code, relating to negligent acts and omission, a person is not criminally responsible. A person is not criminally responsible for an act or omission which occurs independent of the exercise of his will, or for an event which occur by accident, unless, mark the word, unless the intention to cause a particular result is expressly declared to be an element of the offense constituted, in whole or in part, by an act or omission. The result intended to be caused by an act or omission is immaterial unless otherwise expressly declared. The motive by which a person is induced to do or omit to do an act or to form an intention is immaterial so far as regard criminal law. You know, this question is very concise and at the same time said a lot of things. Like it says, if I will begin to analyze this thing, believe me, even a 3 hours video will not be able to analyze what is contained here. But by God's grace, we'll just point out the one that matter. So this provision lays the foundation of criminal liability under Nigerian law, establishing what? Voluntariness, accident, motive as the three pillars of intention in mens rea. So what these provisions establish ipso facto is what? Accident, voluntariness, and motive. These are the three things you don't joke with in criminal law. You talk about voluntariness, you talk about accident, you talk about what? Motive. These are the three pillars: voluntariness, accident, and motive. These are the things the court will consider whenever you talk about crime, as far as the physical element has been proven to exist. The purpose and importance of this section is what we are going to look at now. First of all, I want you to know that section 24 of the Criminal Code basically protects the innocent mind from punishment and ensure that it is only voluntary act or conduct that is being punished. Are you with me? So section 24 is trying to ensure balance, that you are not just ambushed, okay, because you did this, you did that. The law is not ignorant that we are human. The law is not ignorant that things can happen. So assuming there is no section 24, all of us must have been in prison. Every one of us must be in prison, because there are times things will happen. You didn't plan it. You cannot go to prison. Like the first example I gave you people on my first video on criminal law, I told the people that let us assume that me and my roommates, we are lying in hostel or in my lodge. Of course, I live in lodge. So me and my roommates, we are lying in the lodge. And now Possibly we were pressing phone and then we fell asleep. So on the process, my room, we are lying recklessly. You know that kind of lying when you are pressing phone and you don't tend to sleep. You can wake up and your head is already facing hostel side, and the other one is already facing ICT side. So you can imagine that situation, right? So this is what happened. Me and my roommate were lying, and then my roommate lied beneath my leg. Then while I was sleeping, I had a kind of nightmare, or I had a kind of witch hunting. You know, trust the village. So I had a kind of nightmare or something like that, and then somebody was trying to strangle me, or I was dragging somebody. I then shouted, Jesus, Jesus, Jesus. Immediately, I used my leg and knocked my roommate here. And I hope you know that here is very sensitive here. That's why bone is here. Bone, all animal has a strong bone here because of the sensitivity of this area, here and here. That's why you have skull. They cover. I'm not teaching you biology anyway. So I then knock my roommate here, and then my roommate did like and died. Like, can you imagine what happened? I think that okay, it took life. Like, what do you think will happen? So I have taken the life of somebody, right? Now the police are not there. The only people who could be there if I'm living in hostel, then possibly those people around, because hostel doesn't have only one corner. It has many corners. In my school, they have 4 corners. So assuming I'm in hostel, or now taking the fact that I'm in lodge, possibly it will only be me and my roommates will be in the lodge, and nobody else. The only thing they will see is dead body. The only thing they will know is that I have killed somebody. The only thing they know that this guy, came down to buy mineral and even drag mineral. I was held yesterday. So there could be no presumption that he was sick. And even if he was sick, there is no guarantee that he died that night. So something will have happened. And what may have happened? The law have killed somebody. Are you getting me? This is what a layman should say. But for us lawyers, for us law students, it goes beyond just that. You cannot just assume that Kingsley have killed somebody. Are you with me? You can't, that is why we are different. If this thing comes to me, before I even think of killing somebody, I will think reasonably as a law student. There could seem that I have gone wrong in the night. So if you met a lawyer now and then telling him this story, the lawyer will then ask you the truth. What happened? You explain your nightmare to him, how you knocked him here and he collapsed. So the lawyer will make a case for you. Not that you didn't kill, but the case he'll be making for you is to absolve you on the basis that you didn't form the intention to kill your roommate. Are we together? Are we together? If you are together, like the video. If you don't like, me and you go follow here to this video end, because that's stingy way they worry you, they worry me too. Like the video, may will continue. If you have like, God bless you. So if you look at this situation now, you will possibly see that for a layman something has happened, which is death, and there is punishment. But for us lawyers, we have to make a case, because this guy cannot be taken down simply me, not this guy. King's advocate cannot be taken down because I was in a nightmare. I didn't intend to kill my roomie. What happened was nightmare. What happened was spiritual attack favored by physical elements. That is what happened. So will you convict me? No. Why? Which ground will you not convict me? Because I didn't form the intention. That is where the lawyer will invoke section 24 on my behalf. And if he has established it and the court take judicial notice of it and admits it as an evidence, I'm going to go. The only thing he has to show is to prove that actually this is what happened. And if the court accepts, once the court accepts it, remember, if you are going to court, you are not proving law. You are not going to tell the court that section 24 said it. What you are proving is a fact that must align with section 24. And if the court accepts it, your fact that it aligns with section 24, they are bound to apply section 24 to exempt you. So this is what basically happened, or this is what basically the courts do. And now, that is what I'm trying to tell you, that section 24 tries to exempt the innocent mind, not innocent in physical element that you didn't kill, but because your mind is innocent. Because the general principle is that no person shall be condemned when he didn't have the intention to commit a crime. Women against DPP. I have discussed that in my first lecture video on criminal law. So let's proceed. Now, the problem is that Nigerian courts, following English principle, have continually struggled to balance the two competing goals. So that is the problem we have, which I believe is applicable to all common law, because the judgment on this field has not been consistent. Because it is, that is why Justice Bryan once said that even the devil nowhere know the heart of men, let alone lawyers and judges. So the devil don't even know the heart of men. It's only God, omniscient, omnipresent, can tell what we have in mind. So since we don't know the heart of men, lawyers, we can't actually say that Kingsley didn't have any other plan before strangling that guy or before using his leg too. It could be planned, though. Yes, so it could be pre-planned. So what we judge here is the surrounding facts, elements. So we don't know what he have in mind, because we don't know. We only judge based on what we see, because we are human. So So that is why the judgment has been conflicting, because the other judge will judge this one, the other judge will say this one, you say this one. It becomes a problem of lawyers and law students, because ours is to keep following them. If they follow A, we follow A. If they wake up tomorrow and say it's no longer A, we follow them again, thereby increasing our stress as law students and lawyers. So historically, Section 24 was ignored until it gained prominence in the case of Awud case after Nigerian courts began applying it more vigorously. So if you are in a Nigerian, Section 24 was irrelevant before, up until Awud case, where the court begin to emphasize on the importance of this section. But right before that, ab initio, the common law don't joke with this principle, because that has been the basis to spare the innocent from the accused. For a crime to be a crime, there must be physical element, actus reus. There must be what? Mental element, mens rea. And then there must be number 3, absence of defense. So physical element means there must be dead body, there must be rape, and so many other things. There must be stealing. Mental element means there must be intention to kill that dead body. There must be plan to have killed that dead body. Then absence of defense means you were not insane when you are doing it. You are not drunk when you are doing it. We are not doing self-defense. So even if you have killed and it shows that you can possibly show that it was act of self-defense, the court will exempt you. Are you with me? Even if you have killed and you are under the influence of alcohol, which was not occasioned by you, the court will exempt you. Even if you have killed and you are below the age for murder, the court will not convict you. Do you see? These are the things that the court to check. It's not just enough. Absence of defense is another thing the court check, even if you have killed. But in all these cases, there must have been consent that you killed, but you are then telling the court that I killed based on this, on that. Therefore, I should not go in for it. Not that you didn't kill. There are different things. So if you are defending yourself that you didn't kill, you must not rely on what? Section 24. You only rely on it if you know you have accepted, but then you are trying to exempt yourself from it. So now, because I love you so much and because I'm your passionate tutor, let me take you to cases that possibly you can copy from here and use for your examination. It's going to be of immense support to you. So let's analyze it by cases, because section 131, as section 131 of evidence act, as we all know, simply say that he who has must prove. So it's not just enough for us to keep rambling without backing it up with authority. Now, let's talk about authority. There is a definition that I want you to go with about mens rea, which was given by no other court than the Supreme Court in the case of Involuntary and the state, where they say that mens rea can be described as a malice aforethought, a predetermined intention to commit an unlawful act without justification. So similarly, in the case of arm over and R, the court further held that to determine whether the mens rea is an essential element, what must refer to the specific statute creating the offense. I have fused so many things together. The first one in Buckley and State is that mens rea is aforethought, is a malice aforethought, meaning it is something that you have conceived, that you want to do this thing, you want to rape this girl, you want to steal this goat, you want to kill this person, you want to commit this examination malpractice. If you want to commit examination malpractice, for them that do it, it is before the examination hall the person will prepare for it, not the examination hall itself. Before you go, you must have armed yourself with all relevant, almost that you can use to back yourself up. These things, when you are doing all those, you are forming the intention. So that time you have not committed the act, the actus reus, but you already painted the whole picture in your brain, how you are going to do it. If lecturer come, how you are going to dodge it. Some even puts here. You understand? So these are what you are doing, a premeditated act of thought, what we regard in law as of a thought, of plans. So in this case, you cannot claim that you went it away. You are planning only to execute it physically. Are you aware? So this is what we then called, intention. That is what the court is trying to say in the booklet and the state. And in the further case of arm offer against R, the court is saying that for you to determine intention, you must look at the specific law providing it. That's why I want you to, after watching this, we go back to our first lecture video playlist on criminal law. Because I told you people that strict liability offenses, mens rea doesn't apply. Once offense is strict liability means that once you committed the act itself, it doesn't matter whether you are aware, it doesn't matter whether you have intention or not, you are going in for it. A good example, like I gave you people in that video, was Official Secret Act, which will be a topic you will treat in second semester criminal law. In that place, what the court or what was described in that law is that You have no right to enter any place that has been declared to be an official secret. Official secret means something that they cannot be revealed, like the ammunition we have as a country, the ammunition of United States. It's security sensitive area. You don't go in there and without being convicted. Whether you are going there to seek for your girlfriend, for your boyfriend, to save your mother, to save your daddy, once you are not eligible to enter there, if you enter there, you must face the law. Whether you have the intention, whether it's by mistake, these are strict liability. And most often, strict liability only comes when the law is trying to protect something that is very, very necessary and very, very helpful to the well-being of the society. So these are the only places strict liability offenses can arise. So are you with me? Now we are talking about the fact that Amofa and R, the court is saying that for you to say, talk about intention, you must look at the specific provision providing that crime. So if you throw the wording of the statute, you will know whether mens rea is required. So there is no statute you go and say intention or intention. It depends on the use, knowingly, unknowingly, whoever formed the intent, whoever planned. It depends on those kind of phrases will give rise to the court interpreting in mens rea to a crime or interpreting what strict liability to a crime. If you are not getting what I'm saying, ask your question on the comment section. Now let us move to another stage of this lecture. The limbs of section 24. Section 24 has a lot of things like we started. So it has limbs. It's those limbs we want to consider now. Now, the first limbs of section 24 is voluntariness. So he talk about the act must be done willingly. If you can refer back to the definition we gave or the wording of that section, you can actually carry your criminal code while you are watching this video, so you can be flowing. So first limb talk about voluntariness. It says, and I quote, a person is not criminally responsible for an act or omission which occurs independent of the exercise of his will. What this thing is talking about is what? Voluntariness. So if something occurred and it didn't happen from your own way, you didn't form the intention, you weren't ready for it, this thing happened involuntarily, so the law will not hold you responsible. That is the first limb. So this means that criminal liability only arises when an act is voluntary. A person cannot be guilty of a crime for something beyond their control, such as an involuntary reflex or unconscious movement. Like I told you people, example I gave you people about me and my roomie, and me being in dream and choking my room and my roomie went to the world beyond. I cannot be held liable. Are you getting me? So because it was what? Involuntary. But then it is very important to know this thing, please. For the fact that it is involuntary, section 24 will not avail you, whereby the law has expressly provided for negligence to be a crime. I told you people about me and my room, and then me choking my room. If the law has said this thing is example, but if the law has said that this thing happened, regardless of like strict liability I talked about, this one is saying that if you are negligent, and then any section of the criminal code or penal code have penalized that negligence, section 24 will not avail you, because it says subject to negligent act and omission, meaning that wherever the law has criminalized negligence act, whether you are intended it or didn't intend it, the law is going to come for your head. Now let us talk about a very popular case, which is the heart of section 24. As far that's why I said whether you are in Nigeria or not, because it's going to be beneficial to you. Now let's just talk about Timbukolian and R. In the Timbukolian and R, what will happen is very interesting. A husband, a wife was nagging. Nagging, I mean, it was, women and they can vacation. He was just rambling, talking dirty, all those things against her husband. So then the husband was angry. The husband wanted to caution her, wanted to, to just shut this woman up, that this woman talked too much. And then, wade a blow, throw a blow like this to the woman. Unfortunately, the blow landed on the hand of the baby. It was in the dark. So I think there was no light. Let us assume NEPA took light. And then he threw that blow. It landed on the head of innocent baby child, which was also his own, child, beloved child, begotten child. And then the child died. So remember, it is not the individual that prosecutes. So you cannot say it is my son now. Namiki, my son, why will I prosecute? The state must come for your head, because the child belongs to the state, not to you, as far as crime is concerned. So he was prosecuted, and then the prosecution tried to lead evidence to show that this man didn't intend to kill. While on the other hand, the prosecution then tend to lead evidence that this man killed. While on the other hand, the defense counsel tend to lead evidence that this man didn't kill. It was by accident. So the question before the court was, can this man be guilty of killing in the midst of this surrounding facts? So the court then has to say that, according to Windia J, that the blow was not intended, that the blow was intended to the woman and not to the child. And for the fact that it was, the child that received the blow, and not only the child that received the blow, the child died, and not only the child died, that this thing happened in the dark, this thing is then an accident. Events that occurred by accident. But there was discrepancies in judgment. The other part we are talking about, that it was independence of his action. The other judges, was saying that it was independence of the man's will. Then the other judge is saying no, it cannot be independence of the exercise of the man's will. Remember, we are talking about them. First name talk about voluntariness, independence. The other name is talking about accident. We shall still come to that. So the other judges were saying no, it can't be, because if you say independence of a will, the man intended to give a blow. For the fact that the child received it does not make it him to be said that he didn't plan the blow. But the other judges is then saying that it is accident. It is accident because the blow was, not planned to the child. So which side are you taking now? Are you saying that the blow was independent of the exercise of wisdom? In other words, it was not something that was coming from his plan. Or are you saying that it came from his plan, but it was an accident that he landed on the baby's head? So I actually adopt that one of the letter, which is about accident, because if it is involuntary, giving a blow was planned to nag the mother. So he was trying to caution the mother to shut up. So he cannot say he's independent. But some judges say that he's independent. But me, I agree with the one of those who say that it was what? Accident. Because it's actually accident. It was the child that received it. So the court held that the person is not guilty of Timbukolan, is not guilty of murder, because the act was unintentional. And this was the English court view. So this thing is still a locus classicus in Section 24, and Section 24 is close to Section 23 of Queen's Code. In case you are watching from Australia, just know that Section 23 of the Criminal Queen's Code, which is still applicable to your jurisdiction, is still what we are discussing in another outlook here in Nigeria. Now, let's also talk about the second aspect, which is what? Accident. And now let's also talk about the second limb, which deals with accident. The second limb said that a person is not guilty for events that occur by accident. So this limb protects a person who commits a lawful act without intention or foresight of harm if an event happens unexpectedly without negligence. So it is considered as an accident under Section 24 of the Criminal Code. So the better way to illustrate this is to give you example. Let us say now that a hunter lawfully shoots an animal. Mind that word, lawfully. So the hunter was hunting in a place that is deemed to be huntable, so to say, and then he lawfully shoots an animal, but the bullet accidentally hit someone hidden in the bush. This is no doubt purely unintentional act. If you are judging it by virtue of Section 24, a hunter was hunting lawfully in a place that is huntable. Because if you go to a place that is not huntable, that is why I carefully use that word lawfully. You cannot go to a park where you don't hunt to kill zebra, trying to kill zebra, and then you kill people who have came to visit and see monkey, and then you call it that you didn't plan it, because that place is not huntable. So if you are hunting in a hunting place, and then it happens that you shoot another person, thinking it's zebra, the court obviously will exempt you based on the virtue of Section 24, because you didn't plan it. Yes, accident is a pure accident. And now I want you to know that when we talk about accident in law, it's different from your regular accident too. It's not the one that happened between motor car and all those things. You can kill somebody, and even if it happened by accident, you can go in for it if you fall under recklessness. So accident in this type of law is different from your regular accident. What the law considers as an accident is something that, a reasonable man in your shoe, just like you are trying to kill zebra, and the human being was hidden in the bush, and then you shot the person. This thing is a pure accident. For the fact that you are driving recklessly and you have an accident and take two people frying akara or eating akara in the main road and send them to early grave doesn't exempt you because it's an accident. The court will check how the accident arose. So accident in legal sense is different from your motor car and any other accident you could think of. So in the case of Agbo and the state, the Supreme Court held that the event is accidental if it is neither intended nor reasonably foreseeable by a prudent person. This case of Agbo and the state, the court says something which I've saw me mention. You can only deem accident as an accident if it is not reasonably foreseeable to a person of a reasonable nature or reasonable capacity. So it's not about subjective, because many people are not reasonable, especially in Africa here. We are always unique. Some people are not reasonable. So you cannot say because the law doesn't judge you by your reason. The law often judges you by a reasonable man. So the whole the law deemed as an accident is something that a reasonable man in your shoe could not have foreseen. But if a reasonable man in your shoe could have foreseen it, but you lack that capacity of reasonability, you will go in for it. The law judges you by a reasonable man's standard, not by your own standard. Are you with me? And let's keep going further, because I promise you people that what we have come here to discuss is authority. So let me keep giving you more authority you can use to argue your case and win the heart of your lecturer. Now let's talk about the case of Iroma 2 against the state. What happened in that case is that the accused, accused discharged a gun accidentally during a struggle. So the court then has to consider section 24 of the criminal code, whether it's to apply it in this case. And one thing about section 24 is that once it is applied, once it is judicially applied by the court, the efforts or the implication is that the accused must go home free, not without condition, not with any condition. Are you following me? So you cannot now apply section 25 and convict the person for manslaughter. You cannot apply section 24 and still, goes ahead to convict the person or to sentence the person for less offense. Once you apply section 24, the person must go home a free man. Are you with me? So that is what section 24 is all about. Now, in that case, an accused, they were struggling. An accused has gun on his own, body. And then they were struggling, and then the gun discharged and then killed the person they were struggling. They were struggling the gun actually. So in this case now, you see that struggling gun was planned, but then the discharge was not planned. They were dragging something and then the gun discharged. So the court has to apply section 25 and say that it was a mere act of accident. That's why I told you people that accident in the eyes of law is always different from normal regular accident we know. Now, there has been a place where there have been a conflicting judgment as per this section 24. Some judges will be saying A, some other judges will be saying B. Then just like I keep saying in my video, it is a problem of us lawyers and law students, because the judges are free to decide whatever they like, but we are not free. We must follow it. And your duty is not to be a judge here. Your duty is to cite principle. If you cite this one, you talk about what you say. You cite this one, you talk about. Don't cite anyone. If you want to cite anyone, make sure you have stated the whole principle, so that you don't know the one you are citing, whether your lecturer will accept your view. So everybody is entitled to their own opinion. But once judicially talking about, once you are speaking as a law student, you must always come to respect authority, especially when it's proceeding from the Supreme Court or that of the Court of Appeal. They are our learned fellow, and we must respect them. So in the case of Thomas and the state, the court, in that case, let me just give you a brief part of that case. The accused slapped a man who fell and died. So Belgo JSC, as then was, see that the death was not accidental, as the act lap was what? Intentional. So, but some legal critic in that case argued that foreseeability, not moral judgment, should be the true test of what? Accident. So foreseeability and not moral judgment should be the true test of an accident. What this case is saying, if you look at the position of Belgo JS in this case, I will still provide you with the fact of that case, but that would be if you go to my lawmadesimplelegal.com, go to my Law Made Simple website, you are going to see many cases, lecture notes that can aid you. Then I'm preparing something which when ready, it depends on the time you are coming across this video. But currently, as I'm making this video, you can check the year to know whether I should be done with what I'm preparing at the time you are watching this video. I'm preparing an intentional work on criminal law, not only on criminal, all courses, whereby I will give you a sound PDF that can replace your textbook as far as, that topic is concerned, that course is concerned. It is something I'm working on to give you all the cases, just to make it as if to say this thing is personal to you and this thing override textbook. Explaining it not just because I'm treating everybody, I'm treating you in particular. I'm going to give you everything you need to know. Just be analyzing it like, I'm discussing with you, and I'll be passionate about it, and I'm passionate in working those things out. So whenever it is ready, I will always have a way to notify you on this channel or through my website. Then you can go and check what it takes to get that free course. So this is something I'm working on, depending on the time you're watching this video. If the time you're watching it have come to, show that it is done, you will then have the opportunity to follow and get it at that moment. Now, in this case of Thomas and the state, the accused slapped a man. So the man failed. The man failed and died. So the death was not accidental according to this learned judge, because the slap was intentional. Then the critic was saying, or those who said the opposite judgment was saying that the slap was not intended for death. So for the fact that the accused died, then it cannot be a basis to justify that the slapping somebody could lead to his death, therefore he should be exempted. So they were saying that they were viewing the Belgo JSC position as that of morality, that it was too amplified by the act of the accused slapping the person in Thomas and state. But that does not mean that a slap could, give rise. But me, I disagree, because slap, for me, I think that if you have done some grievous harm or harm to a person and death results, you should go in for it. There should no basis to free you on anything. That is my own perspective. But the judges are saying no. So in Ademola and the state again, the accused threw a burning stove at the disease leading to death. So the court held that it was foreseeable, hence not accidental, according to Puta JSC. So what this one is another case again. You can still refer to my website. This case if you read this case, like you will just see that I don't know what is wrong with some people. You throw there was a dispute between the accused and the deceased. So he then carried a stove that was burning with his kerosene and everything, and then threw it to the deceased. So the deceased then caught fire, and everything messed up, and he died later on in the hospital. When they came to the court, what this man was arguing, I mean his lawyer was arguing, is the fact that he didn't intend it. For God's sake, he didn't intend it when he threw a burning stove with fire, possibly with hot rice under it, or hot eba under it, and then threw it on somebody, the whole thing catch fire, and the person, what else did you intend again, if not to cause grievous bodily harm? And remember, section 319 and 316 of the criminal code, 316 in particular, if you go there, you will see that it made provisions, and it is not necessarily death. Even grievous bodily harm is enough to give rise, because even if you didn't intend to cause death, and there could be evidence to show that grievous bodily harm was intended, and the person died, you are going in for murder. Of course, throwing a stove, would it cause a grievous bodily harm on somebody? So you can see that there is no better way than what Oputa JSC said, than not to support the argument of the defense counsel that throwing a burning stove was not intended and couldn't give rise to death. Me, I disagree with that contention of the accused and favor that of the judgment of the Oputa JSC as then was. Although, to see again, according to Professor Soba, who made the work I have come across in this section 24 of the criminal code, he argued that that decision is fallible in the sense that the judge were more of looking at the fault nature of the accused rather than looking at the foresight. For them, they think that throwing a burning stove, according to the critics, is faulty in nature, but that could not be in a foresight, that the person who throws this and doesn't foresee that it's going to lead to death. It was not intended killing. For me, I still find it hard to agree with such assertion, because if you throw a burning stove on somebody and the kerosene is on it, what else are you expecting? Even if he didn't die, what else are you expecting? Grievous bodily harm. So I think that method with section 316 of the criminal code. So you have your own opinion. You can put it in the comment section anyway. You can actually contrast Thomas and State with Omoro and State. Thomas and State was decided in 1994. Then Omoro and State was decided in 1990. So in that Omoro and the States, the appellant slapped the deceased who fell and died. The court said that it was an accident, as the death was surprising and unforeseeable. So this case has remained controversial when you contrast it with what Thomas and the State. The other one, they said, Bergo JSC said that it was what? A crime. It was a murder because, he slapped and he fell down and died. And the court said that it was foreseeable. So, but in this case of Omoro and the State, he slapped and then he died. He fell down and died. The court said that it was even surprising, according to the judgment, that it was even what? Surprising, the fact that slap led to him falling down and dying in the first place. Do you support this judgment? So remember all these things, what they are trying to establish is intention. And I told you that whenever you go to criminal law case, one thing the lawyer will always rely upon is this section 24. And section 24 is not denying the fact there has not been killing. It is acknowledging the fact of killing. And then, but it's then relying on the fact that it can be justified on the fact that the person didn't plan to kill. So you have slapped somebody out of argument and the person fell down and died. Then the court said that there was intention by virtue of you slapping. So this was the position in Omoro and the State. But when you contrast it to Thomas and State, you see it's a different thing. So that's why I said their conflicting judgment is a problem of lawyers and law students, but not their own problem. Because they can always come and take another side in another matter, especially when they are exercising their power in appellant jurisdiction. I'm talking with respect to our justices. So do you see how it works? And now, let me take you to the third lane, which is talking about motive. Motive and irrelevance of motive are related to criminal responsibility. I have emphasized this in almost all these videos I've made in criminal law, that motive is irrelevant when criminal law is concerned. So if you are stealing a gari in order to feed yourself because you are hungry in hostel and you are caught, your motive of being hungry, your motive of stealing to eat is irrelevant. If the crime is punishable, you will be punished. You shall be punished. There is no two ways about it. But the difference between, I want you to get the difference between intention and motive clear. Your intention, your motive is to steal gari because you are hungry to feed yourself. But your intention is to steal. Your motive of stealing gari is because you are hungry. You want to feed yourself. But your intention of going to place that gari is to steal it. This is the clear difference. So intention is talking about why you did what you did. Motive is talking about why you did what you did. That is the reason why you did what you did. Then the intention is referring to the actual act you were trying to do. It's referring to that your plan to steal gari. It's not asking you the reason why you steal gari, but your plan that you had intention, that you taking the gari was not under the belief that it was your own. But you are intentional, you know that gari is not your own. That's why we describe ab initio, intention, to mean knowledge of the surrounding circumstance. So you are aware that this garri is not your own, or you are taking it. This is an intention. So I want you to know that section 24 is the fulcrum upon which you must convict a person. So any crime in the world, as far as common law system is concerned, for there to be a crime, there must be a guilty mind. There is no two ways about it. Once the person is not guilty in heart, I'm not talking about contrite of heart or prayer of mercy. I'm talking about once the person didn't have the intention to do that thing, then the issue of crime does not arise. However, remember we talked about recklessness in our previous video, negligence. So if it fell off from intention, another thing the court must consider is recklessness. So even if you are not intended to kill, were you reckless? If you are reckless, you have another crime waiting for you. Even if it was not recklessness, were you negligence? Should you have done something a reasonable man could have done to avoid that death or to avoid that stealing? If that is the case, you are going in for another crime. But the difference is that intention has more weight. Recklessness will bag you manslaughter. But intention, once it is proven, go to law. A death sentence you are going into like this. So we have now considered this thing. The next thing we are going to look at is what? Available defenses. We have not discussed insanity as at the time I conclude this video, depending on when you are watching it. We have not also discussed, defense, bona fide claim of right, section 23. We have not also defense, talk about self-defense. These things are operational, immature age, and so many other things, criminal responsibility aspect. So I encourage you to subscribe so that when we post this video, you will receive it. If I'm not done, so subscribe. And then finally, I want you to, check these videos above because they are going to help you. Check it and see how most of these playlist video help you. I talked